Okay, thank you, ladies and gentlemen. We're here today on House Bill 443, LC 412921. Is that correct, Mr. Leverett? And okay, Mr. Leverett, if you will, tell us about the bill, please.
Yes, thank you, Mr. Chairman. Thank you, Mr. Chairman. I appreciate the committee's consideration of this bill. This bill would purport to adopt the Georgia Structured Settlement Protection Act by amending certain provisions of existing Georgia law. And in effect, this bill would help prevent the unscrupulous from taking advantage of the disadvantaged. In effect, if you like biblical references, Mr. Chairman, throwing out the unscrupulous moneylenders from the temple. So the bill does not regulate the process of entering into a structured settlement, which, as I'm sure you know, is basically a settlement of a lawsuit or a claim in which payments, instead of being made in a lump sum, are paid over a period of time. And that is often funded by an annuity or some kind of insurance vehicle. It doesn't regulate that part of the process. What it purports to regulate is the process by which that structured settlement can be sold to a purchaser. It basically allows the former plaintiff to convert the promise of payment in the future into present value cash for whatever needs they might have. So in that situation, the former plaintiff is in a somewhat vulnerable position, and the act seeks to provide some protection from them so they're aware of what's going on. They've got full information. They have an opportunity to seek other sources of information before that agreement becomes binding upon them. The bill would amend, update, and strengthen protections of existing Georgia law that exist in Title 51, which is the tort code. This is in a provision of Chapter 12 and Article 3, which is somewhat cryptically named damages. The section actually already concerns the sale of a structured settlement and appears to be an earlier version of this current model act, because many of the provisions are similar. But the new law would amend it, would update it, would strengthen it, and in my view, primarily, would bring Georgia into conformity with the vast majority of other states. As I understand it, 48 states have adopted this current model act. And as Chairman Fleming is fond of saying, as a lawyer, he's not real good on math, but I believe 48 is a majority of 50. And I think there's a move underway to have the law adopted in the other state, which has not yet adopted it, which is New Hampshire. And this was proposed by the National Conference of Insurance Legislators. The current law, again, does contain much of the general framework, which is to some extent dictated by federal tax law. But in order to sell a structured settlement or to sell that income stream, there has to be a court order approving it and finding it to be in the best interest of the claimant or the payee, which is the former plaintiff. And this act would, in my view, do two things primarily. It would require that anyone or business who's interested in purchasing structured settlements would have to register with the Secretary of State and post a bond for the benefit of someone who might get taken advantage of in that process. And secondly, the disclosure requirements prior to the transaction or the purchase becoming final are strengthened, and the items that have to be disclosed are further or to some extent increased so that the person can have good information. And finally, there's sort of a self-policing provision in here, and that the Secretary of State is not necessarily required or even authorized to bring suits to enforce this, but other actors in the industry and the claimant itself are given a cause of action to enforce. And some of that can be done in the proceeding to approve the structured settlement purchase, and some of it can be done otherwise, but there is a private cause of action there. We've got a number of witnesses who can talk with much greater expertise and experience about this, so I don't want to lengthen my comments any, but I did just want to try to set up the general topic of this bill that we filed.
Would this also allow a conservator to sell a structured settlement on behalf of a minor?
My assumption is that it would, but I think that's probably a question better addressed to one of the other witnesses.
Okay, all right. In any particular order you want your witnesses?
I've got Jet Tony here, I think, who can sort of tee up the other witnesses, and then if to the extent Jet has any suggestion about the order of them, I'll sort of go with that. But
Okay,
we've
Mr.
got-
Tony, come on up and have a seat. Yes, sir. You want to move in the middle chair there and,
Yes, sir.
okay?
Thank you, Mr. Chairman, for
Yes, sir.
opportunity to work on this. This is kind of the third consumer protection bill that I've brought to this committee over a 20-year period. One dealing with viatical settlements
Mhm.
and consumer protections in that industry. And then last couple of years, we've been representing folks who provide legal funding, but that did not go to fruition last year, but was discussed, and I'm always happy to talk about that. But the notion of this bill, as the author said, is to strengthen the current law that we have. And
Right.
It certainly does that. And that's been evidenced by similar laws passing in other states. In fact, some of those laws, similar laws passed 3, 4, 5 years ago. And so we're getting around to Georgia now. We want to get this passed. It's not lost on me how important this registration process is that currently doesn't exist in Georgia. The Secretary of State being able to find folks and to know who the officers are of those entities, I think is one of the better elements of this bill. Mr. Jack Kelly is someone that could answer your question about conservator for a minor. So we'll see if we can get Mr. Kelly on.
Okay.
I
Mr.
believe
Kelly?
I believe I'm here, Senator. Can you see me?
No, sir.
Representative Scoggins
Who's on?
is the chair.
Okay,
Mr.
we can
Kelly.
hear you.
Okay, Representative Scoggins, how are you? Thank you.
Good. How you doing?
Good. I have my camera on, but it doesn't seem to be doing anything for us. But considering what I look like sometimes, that's probably better off.
Okay, we got you. We got you now.
Okay, I appreciate it, Representative. My name is Jack Kelly. I'm with the McPherson firm up in DC. We represent the National Association of Settlement Purchasers. As Mr. Tony and chair, the sponsor have advised the committee, this is basically taking a law that was created in Georgia back in 1999, before there was ever a federal structured settlement transfer law. That law was passed after the 9/11 victims, and they created this process for the court order, requiring that a local jurisdiction do the court order. After that, in 2003, Georgia adopted and improved that law. But then in 2004, the National Conference of Insurance Legislators passed a model act that they've updated 3 times over the past 20 years or 15 years addressing this. Today, 48 states and the District of Columbia, 49 jurisdictions have the law, and New Hampshire is on the brink of passing it. They've already had their hearings. And what this does is it brings Georgia into line with the other states, and it protects Georgians is what it basically does. There's some bad apples out there in this marketplace that the industry doesn't want conducting business the way they do. This gives the opportunity for the Secretary of State of Georgia to know who's doing business in their state. It dramatically increases the disclosures that are in the existing law, and it makes sure that a person has to appear in court personally, and it makes sure that they have to appear in their county of residence. And that avoids some of the unscrupulous behavior where people forum shop and bring people into Georgia who aren't even Georgia residents. They set up these fake IDs and get them, and then they disappear. So what this does is it brings this law into line with everybody else. And in the case of the question that you posed, Mr. Deere, I'm sure who's going to join us for a second, as the executive director of the organization. Minors traditionally, if there was a reason to access that money, would likely go under a different procedure under the conservatorship. If that money were needed for their health and welfare and caring to accelerate the payments, you would go back to, you more than likely go back to the original underlying court of jurisdiction. This is, if this were a minor who reached their majority, say 20 years later, and their parents had died in a car accident and they were receiving monies for that, and they wanted to have access to some of that money, they would go under this proceeding, and a judge in Georgia would look at it and say, determine if it's in their best interest based upon the information. So in the conservatorship case, the conservator would still protect the individual and the underlying structure would still protect the individual. So that would be external to this transfer process.
Okay, thank you very much. Any questions? I know we have a couple online. No questions. Thank you very much.
I appreciate it, Mr. Chairman. Thank you.
Thank you. Okay, anything else, Mr. Tooney, you need to add? Okay, do you have other witnesses?
I think we had, is Brian Deere available or is he not online?
Is he online?
I'm available.
Brian Deere? Okay, all right. How you doing, sir?
I'm doing well, sir. I'm sad that the pandemic is keeping me from Georgia. I was actually born in Riverdale and spent most of my formative years in Roswell and Woodstock and Dunwoody. And I have a soft spot for the hot dogs, which my wife would prefer I not eat. So at some point, I hope to get back there and see you guys and have a chili dog and a frosty orange. But in any event, as a
Pretty hard to turn down, isn't it?
it really is. It is sometimes worth the face I get from my wife when I put a couple down, but better for better or worse is what she signed up for, and that's definitely on the worst side of the column.
I hear you.
But
Okay.
in any event, as Mr. Kelly alluded to, I'm the executive director of the trade association, the National Association of Settlement Purchasers. Additionally, I am also a practicing attorney, and I handle a number of these cases under a very similar, I'm based out of North Dallas. I'm very happy to say we have power today. That was not the case last week, but we have a very similar kind of setup of the act, which is before you in Bill of 443. I can certainly walk through some of the processes with you regarding the logistics of how these cases operate. If the committee has any questions, kind of to dovetail Mr. Kelly, this bill is something that will be very beneficial for structured settlement recipients in Georgia. It greatly expands the front end disclosures for any person who wants to look into one of these transactions. One of the first documents that they will get is a disclosure statement, which if they've reached out to a company doing business in one of these transactions, receives an offer, it would have the details, all the financial information on that disclosure statement. It would also advise them that they have the right to go talk to an attorney or a financial advisor. It would advise them that they have the right to go talk to other companies to get other bids, essentially to make sure that if they want to shop around that they can do so and they understand that, just to make sure that they can negotiate and get the best prices available for what they might need to sell. Also gives them a very clear indication of what the effective interest rate is on the transaction, something that the current law doesn't have. Additionally, this bill would provide in companies that are involved in this space, in the pleadings that we would file with the court, it would provide the court further information about the transaction, as well as a little bit about any past transactions the person's been involved in case the courts want to have that information. And then going into the registration requirements, as Mr. Kelly mentioned, this bill would allow a pretty straightforward and simple process. We have one of the companies, one of our members who's based in Georgia, who's going to testify after I'm concluded here in just a second. But it provides a registrations process. It's pretty simple. Essentially, you register to do business with the Secretary of State. There is a $50,000 bond or letter of credit put into place just in case if anything ever goes awry, that there is a vehicle for a customer in Georgia to get some relief if that ever comes to fruition. Then it also provides a number of prohibited acts that additional protections for Georgia customers in their interactions with these companies. There are certain things that companies are going to be restricted from doing, and then if they were to violate one of those prohibited acts, it provides a vehicle for a Georgia customer to have a right of action against that company, or in certain circumstances, if there is a company who is really up to no good and trying to commit some fraud against someone who is already involved in a transaction with a different company, in certain circumstances, it would create a right of action for a company who is involved with a Georgia customer if there is some wrongdoing or shenanigans. There are unfortunately some bad apples, as Jack alluded to, in this marketplace, and what our organization does, and our organization is basically made up from a number of companies in this space. What we are trying to do is to make sure that the process put into place is, doesn't cause any problems for people in Georgia who want to complete one of these processes, but want to make sure that they're being as protected as much as they can while still allowing them the freedom of being able to access some liquidity from their structured settlement should they need to do so. One thing that you had mentioned about something I wanted to also speak on very briefly regarding what would happen in a situation with a minor. So the way that those transactions typically work, and I will tell you that they're very rare. Most of the transactions that our members are involved in are, typically with adults, but there are certain circumstances. Probably in my practice here in Texas, I maybe have 1 or 2 cross my desk in a year, and first, I will review them and just kind of make sure this is something that is going to be both beneficial for a minor before I even get started and take the next steps. In Georgia, similar to Texas, I'm sure that there is a law that governs essentially there's a process if there is a guardian or a parent who wants to sell the property of a minor. There is generally a court process set up to that in place to protect the rights of children in those cases. What we do in those circumstances, if there is a case that's appropriate, where I say, for example, a minor had lost a parent in a wrongful death and they had a structured settlement set up, and when they're 14 or 15 or 16, something arises where they might benefit from that liquidity. What will typically happen is that they may actually have to file kind of a hybrid action that's both requesting permission of a court under what would typically be the provision governing the sale of minors' property, as well as this law as well. So it may actually be a hybrid action, taking in to make sure that they're compliant of both the Structured Settlement Protection Act and then whatever laws in place regarding the sale of a minor's property. Again, those cases are very rare. I think the last one I had a 16-year-old out in West Texas who was heavily involved in FFA, who desperately needed a pickup to get to all the different farms she was working. And we went through a process, and it was a fairly small transaction, tailored for that purpose. But that's essentially what those cases typically would look like. And then finally, just kind of wrapping up, if there's any questions that you have about this process, about kind of the logistics, how it works out in court, I would certainly welcome those questions. If you have any questions regarding, specifically how these, this bill would further enhance protections, I'm certainly welcome to take any questions that the committee may have. I also want to thank very much the committee for allowing us to appear remotely, although again, I wish I could get my varsity.
I understand. So this bill really is just going to require anyone who's doing this to register with the Secretary of State's office and post a bond. Is that correct?
It does that. It also implies some additional prohibited acts that these companies cannot partake. So that's part of it. Again, it expands the disclosures on the front end to give people involved in these transactions further information. And then it also, one of the things that I believe Jack also mentioned, it also requires, currently in Georgia, you could have a person who was living where my great grandfather used to live, down in China Hill. Although to be fair, I'm not sure if China Hill is still on the map. It's that old at this point. It's kind of a ghost town now. But if a company had, sometimes would file a case with a person down in China Hill up in the Atlanta area, if it was a perhaps a better venue for the company wanting to get one of these things done. What this allows is, or also requires, is that if you have a Georgia resident who's in Cobb County, that case is now going to be filed in Cobb County. If you have someone who's going to be in Chatham County, that case is now going to be in Chatham County versus in whatever courthouse that they decide is most beneficial for the people trying to get these deals done. Where that kind of comes into kind of the bad apple scenario. And again, this is not something that our membership is participating in, but there are unfortunately some outfits out there who will, if there's a buck to be made, they'll find a way to make that buck. And what we have seen is unfortunately people who are in other states that might be a little bit more difficult to do business, occasionally will run a person through a county that they see to be beneficial. They might have someone come in, get, set up a long-term stay somewhere, get themselves a Georgia ID, run them through whatever county they think might be appropriate to get a deal done easily. And then at the end of the day, they're coming in, getting a deal done in Georgia when you have a Tennessee resident, an Alabama resident, or someone from up in the Northeast. So those are the kind of the loopholes we're trying to close by the combination of registration and then also having these cases heard in the county where the payee resides. That's really going to put the squeeze on anyone who's going to try to take advantage of the Georgia system as it's currently set up, just to kind of stop that bad practice.
Okay, thank you very much.
Thank you very much.
Amanda Dopeman, is that correct? Did I miss it? DeBarton. Okay, I'm sorry, DeBarton.
I'm here. Can you see me?
Sorry, I chopped that name up.
That's okay. It's actually pronounced Dobanton from my,
Dobanton, okay.
yes, but I would never know that unless the way I say it as a Georgia resident is Dobanton.
Okay,
But I am here. Thank you for having us today. I am a Georgia resident, born and raised, and actually am a business owner, own a structured settlement purchasing company, a member of NAS, their national association, and a member of the Georgia Bar Association. So I have the rare opportunity to really be involved in these structured settlement transfers from start to finish. So from actually dealing with the recipients, the individuals that are selling their payments, to their paperwork that they're receiving, to the registration, bonding, and to going before judges and getting court approval on these. And so I just wanted to speak today, and I'll be brief. I know that your time is valuable, but we as a company registered in Georgia, we are in favor of this. We consider ourselves one of the good apples. We've heard a lot about the bad apples, but we're one of the good apples. And I want to be in this business for a while, and I would like this business to continue. And the only way to continue this business is to continue to make improvements and adjustments as things change and as we see new situations arise that, hold companies like us accountable, that protect our payees, and that, protect the states in which we do business. And so we think that this version and this amendment to our current statute accomplishes that. And so we are in favor of it. And I just wanted to answer any questions I could answer that you guys may have, or that you all may have about this amendment.
okay, is there any questions from this witness or for this witness? None. Thank you very much.
Okay, thank you.
Okay, no other witness, any amendments? Anyone? Yeah. And do I have a motion?
So move.
A motion and a second. All in favor?
Aye.
Any opposed? Okay. Move on to full committee. Yes, sir. Yep. Okay, we're moving on to House Bill 99. Representative Stevens, are you still online? Okay. Representative Stevens, are you there?
Yes, sir. Thank you, Chairman Scoggins, very much for the opportunity to present the substitute to House Bill 99. It is called the Access to Employee Toilet Facilities, strangely enough. In retail establishments, the problem that we have for those folks that have a very serious condition that keeps them homebound, if you will, whether it's Crohn's disease, ulcerative colitis, inflammatory bowel disease, and others that might require some sort of ostomy device. This is more of a that legitimizes the person that comes up that does not have a public restroom. And by a signature of physician, it tells them that they are legitimate, so that they can, if the business so chooses, to allow them in an emergency situation, because they truly can't wait, to use their facility if they so choose. There is no punitive damage if the businesses decide not to do that at all. This is more of an education, if you will. So, and I know we've gotten some physicians on here that are that treat these diseases, and we've also got some folks that wanted to testify as well. It is more of a education process, if you will, and it just allows these businesses to know that if possible, whenever these folks show up and they cannot wait, that they are legitimate and they really are in need of some help.
Thank you, Mr. Chairman. We have Christy Edenfield, who is a witness, is going to testify today.
Yes, sir.
Okay.
Thank you. And there's another number of people that will go after me, if you please. Thank you, Chairman Scoggins, and the honorable members of the distinguished committee for allowing a hearing today on HB 99, the Restroom Access Act. My name is Christy Edenfield, and I have had the good fortune of being a constituent of Representative Ron Stevens since 1997, when he was first sworn in. About 2 years ago, we had breakfast together at our local Waffle House in Savannah. I was talking to him about this bill, and he quickly agreed to sponsor it due to the fact that in his profession as a pharmacist, he has witnessed the difficulties that many of his constituents who live with Crohn's disease, colitis, and other chronic IBD health issues have. This bill is supported by the Crohn's and Colitis Foundation, the Medical Association of Georgia, Georgia Nurses Association, Georgia Osteopathic Medical Association, Georgia Chapter of the American College of Physicians, Georgia Chapter of the American Academy of Pediatrics, Georgia Gastroenterologic and Endoscopy Society, Georgia Coalition of Advanced Practice Registered Nurses, Atlanta Medical Association, Society of Gastroenterology Nurses and Associates, Georgia Academy of Family Physicians, National Association of Pediatric Nurse Practitioners, and the Georgia Association of Physical Assistants, along with numerous doctors and patients. According to the Crohn's and Colitis Foundation, there are 84,000 IBD patients in Georgia, and almost 10,000 of those are children. If passed, Georgia will be the 18th state to pass this law. Other southern states include Kentucky, Tennessee, and Texas. It is also being considered in the legislative bodies in many other states this year. The law requires businesses to allow people with inflammatory bowel disease, ostomies, and other medical conditions to use employee-only restrooms. Allie Bain, a 14-year-old girl from Illinois, had a flare-up of her Crohn's disease while shopping at a large retail store and was subsequently denied use of the employee restroom, causing her to soil herself. Bain's mother vowed it would never happen to anyone else. The two met with their Illinois state representative, who helped her to draft a bill and testified before a committee at the state capitol. The bill was signed into law in August 2005, making Illinois the first U.S. state to do so. We are proud of the fact that Georgia could be the next state to pass this important legislation. I myself have been denied access, and it makes living with Crohn's disease even worse. The illness limits the ability to live a normal life. It is an isolating illness, as people who have Crohn's and colitis oftentimes limit their activities outside of their homes. Every patient that I have ever spoken with has stated that the first thing that they do when they go anywhere is to locate the bathrooms. A joke that people who have these chronic conditions often tell is that our superpower is knowing where all the bathrooms are. There is no cure for Crohn's and colitis. There is not a lot known about these chronic conditions. There is no certainty about why people have these inflictions, and there is no definitive medical research about what causes a flare-up. It is unique for each individual, so there is no one-size-fits-all treatment. Reporting favorably on this bill will put us one step closer to making life a little bit easier for Crohn's and colitis patients. And it would give us, those who live with this illness, a little more assurance that when we have the freedom to participate in our communities at a greater extent. Being denied bathroom access when you are having a flare-up episode is mortifying and embarrassing. HB 99 will ensure that no Georgia citizen has to experience this type of humiliation again. Thank you for hearing this testimony. Next, I would like to introduce Dr. Doug Wolf with the Atlanta Gastroenterology Associates and Dr. Ben Gold with GI Care for Kids. Thank you.
Okay, Ms. Enenfield, you were the only one who actually signed up to speak today. So I'll hear from a couple of more and we'll stop at that point. Okay. If you got a preference of who you want to speak.
Thank you.
Okay.
Dr. Gold, Dr. Wolf will be next.
Okay.
Thank you, Chairman Scoggins. That was a great introduction to what I have to say going forward. I'm Dr. Douglas Charles Wolf, and I've practiced gastroenterology in Atlanta for 36 years, specializing in Crohn's disease and ulcerative colitis, the two types of inflammatory bowel diseases known as IBD. For 8 years, I practiced at Emory Clinic, Emory University Hospital, the Atlanta VA, and Grady Memorial Hospital. And for the last 26 years, I have practiced at a large gastroenterology group, Atlanta Gastroenterology Associates, directing and co-directing the Center for Crohn's Disease and Ulcerative Colitis, and doing IBD clinical research. For 30 years, I have been a member of the Crohn's and Colitis Foundation, and at different times have served as chairman of the Georgia Medical Advisory Committee, chairman of the Foundation's Professional Education Committee nationally, the Professional Education Committee and Membership Committee, and the National Scientific Advisory Committee. And I've also served as president of the Georgia Gastroenterologic, a word that is hard to say, and Endoscopic Society. Crohn's disease and ulcerative colitis are chronic diseases which have no cure. They are diseases of a lifetime. Inflammation and ulceration of the GI tract is the predominant feature, and this can be likened to a severe burn and blistering affecting one's insides, one's intestines. In Crohn's disease, any part of the GI tract may be involved from the mouth to the anus, most commonly involving the small and or large intestine. And in ulcerative colitis, part or all of the large intestine is involved. As said, these conditions affect 3.1 million people nationally and 84,000 people in the state of Georgia. Common symptoms include severe bloody diarrhea with up to 20 or more stools a day, severe abdominal pain, loss of appetite, weight loss, nausea, and extreme fatigue. The diarrhea and the condition may be disabling and just uncontrollable. Bowel or stool urgency may occur such that one has little or no warning to get to the bathroom. In Crohn's disease, the inflammation and ulceration may burrow through the wall of the intestine, causing fistula and abscess in up to 1/3 of patients. This further worsens control of stooling, increases the chance of fecal incontinence or soiling, and clearly complicates the condition. Such urgency to have a bowel movement can be unpredictable and may be so sudden that a patient soils their underwear and clothes. Some patients may bring an extra pair of underwear and clothes with them, but that is not enough. For those of you who have had a colonoscopy and prep, uncontrollable urgency is the feeling you get from having drunk the whole prep. I know, and I'm friends with a Crohn's disease patient and attorney at a prominent firm who, upon becoming a partner, was asked which office she preferred, and without hesitation, she said she wanted the one next to the bathroom. Medications used to treat Crohn's disease and ulcerative colitis include oral anti-inflammatory pills, rectal therapy such as suppositories and enemas, biologic medications which may be given by injection or infusion. Historically, 80% of Crohn's patients require one or multiple surgeries, and 30 to 40% of patients with ulcerative colitis require surgery to remove their entire colon and rectum. A diversion of the small intestine to a bag adhered to the skin, called an ostomy, is temporarily or permanently needed. Most patients experience significant anxiety and depression due to the unpredictable nature of urgency and severe diarrhea. Not knowing if they will have access to a bathroom prevents Crohn's disease and ulcerative colitis from going places and creates further isolation. I wholeheartedly advise passage of House Bill 99. Patients with Crohn's disease and ulcerative colitis need the option of immediate restroom access as an appropriate and humane action. Just as 17 other states have enacted similar legislation, Georgia must act now to support and protect patients with Crohn's disease and ulcerative colitis. Thank you very much.
Thank you, Dr. Wolf. Is there any questions for Dr. Wolf? None. Thank you very much.
Thank you.
Ms. Enfield, who was
Yes,
the other witness you had?
Is Dr. Gold there?
Yes, I'm here.
Okay, Dr. Gold, will you go next, please?
Sure thing. I think Honorable Bruce had a question. You were raising your hand.
I did. I had put it in the chat. I didn't know if you were looking at the chat or not.
Okay.
What the question that I put in the chat is, if there's no punishment or requirement to comply with what you're doing, I'm not sure I understand what the point is, because the idea of educating people can be done without a law. But I would like to see, because I understand exactly what you guys are pushing. I'd like to see that there is a requirement to comply. I mean,
And
it would be a requirement.
and Representative Ron Stevens can address that.
Go ahead, Representative Stevens.
We originally had it as a misdemeanor in there, but it was brought up to us by the alleged counsel that during these times of COVID, that we may be putting an undue burden on some of the businesses that may feel like that they're somebody coming inside of their business where they're trying to seclude those might be a problem. And we couldn't find a reason or a way to put this into the bill, but I'm open to that as we move along.
Yeah, I mean, if I owned a business and somebody came and told me that they had one of the diseases that you're talking about, and the option was that they use my bathroom or go right there on my floor, I'd open up the door in a heartbeat.
So would I.
So I mean, okay.
Okay, Representative Bruce, do you want to make an amendment or anything, or is that something you're thinking about?
Well, I mean, if, I don't want to slow up what Representative Stevens is trying to do, but I think we should make it a penalty. But if he's already checked and you feel like that would slow up what you're doing or prevent what you're doing, I don't want to do that. So if you are open to it, Representative Stevens, I will make the amendment. If not, I won't.
Yes, sir. I am open.
Okay, then I will make the amendment.
Okay, we'll get to your amendment in just a minute. Let's hear from Dr. Gold.
Sure. So I won't, I think Dr. Wolf highlighted a lot of the points I will not have to go over. And I want to thank the esteemed council for having me be able to present today in behalf of not just the Crohn's Colitis Foundation Georgia chapter, but also my children and families with IBD patients. I'm a pediatric gastroenterologist, so I take care of kids till they're 18 to 21, and then I pass them off to Dr. Wolf. and have been a pediatric gastroenterologist here in Atlanta for almost 28 years. I was 18 years at Emory, head of the division for 11 of those 18 years, and chief of service at Children's Healthcare of Atlanta of GI. I've been at GI Care for Kids now for the last 11, almost 12 years, and board certified in pediatric GI and in pediatrics. I also belong to the Georgia chapter of the American Academy of Pediatrics, and I'm a fellow of the American Academy of Pediatrics. And interestingly enough, this is something that the American Academy of Pediatrics, which represents close to 65,000 pediatricians across the United States, is very supportive of, and happened to be the current president of the North American Society of Pediatric Gastroenterology, Hepatology, and Nutrition. The abbreviation is NASPGHAN, which represents all of the pediatric gastroenterologists in Canada, the US, and in Mexico. Unlike my adult gastroenterology colleagues, where almost as many adult GI are here in Georgia as there are pediatric gastroenterologists in the entire country, there are not as many of us. There's some states in this country where there are only 1 or 2 pediatric gastroenterologists. And I've been taking care of children with IBD for my entire career. In fact, actually, I belong to the Georgia chapter of CCF. I've been on the board and very active with the Georgia chapter, particularly with our programs of educating families 4 years in a row. Now we've had a family and a child education day. Camp Kaleidoscope, which is a camp that we run every summer, which has been phenomenal. Now actually 3 different states come to our camp, which is the first in the country. And I think most importantly, I'm very active with the advocacy committee for our national society in advocating for support for our children with IBD. About 30 to 35% of children of all patients with IBD begin before their 18th birthday. And I would be willing to bet you that at least 20% of adults who are diagnosed with Crohn's or ulcerative colitis probably had symptoms before they hit age 18 to 21. And it just, they never really put all the things together to figure out the diagnosis. Despite the fact that we've known about IBD since the late 1930s, when Dr. Crohn's described it in his 3 relatives in an infamous, now famous paper in the New England Journal at that time, it still takes on average between 18 months to 3 years for the diagnosis. For many children, and particularly for teenagers, and if any of you all have kids or have dealt with teenagers, this can be not just a difficult challenge when you're already dealing with trying to figure out what your role in life is, how you interact with your peers, but to have a condition that makes you go to the bathroom sometimes 5, 6, 7, 8 times a day, long hours, and then sometimes you have to get up at night when you're sleeping to go to the bathroom. It can be tremendously debilitating. And as somebody who takes care of kids who have lots of bathroom problems, not just Crohn's and ulcerative colitis, I can tell you that many kids will avoid at all costs going to the bathroom, even in schools, much less when they're out in public. And so when they're out at the mall with their parents shopping or at the grocery store or somewhere else, and they have the urge to go, at least with these conditions, you can't wait. And so you've got to go. And so you run into some fairly significant problems. And many times these kids just, when they're having a flare and their disease is active, they don't want to leave the house because they're afraid of going somewhere where they're not going to be able to have access to the bathroom. I was involved as a consultant for the Crohn's colitis of the UK. And in fact, they've got a very similar legislation that has been passed in the United Kingdom. So I'd like to say, at least here in Georgia, we need to be able to be one of those first few states that puts this bill and passes. And I really appreciate Representative Bruce for opposing that. Something like this with teeth will allow families to have access when they can get out. So if their child has to go to the bathroom, then they can have access. It's important to recognize that this is not an infectious disease. This is not catchable. This is something that it relates to both the genetic predisposition plus something that flipped the genetics on so that the body's immune system attacks itself. And I think where a lot of people misunderstand is they think, well, you have diarrhea and you have an infectious disease. They do not. So they're able to if they're able to get to the bathroom, they're able to do their thing and then go back and finish whatever they have to do. So I'm going to leave it at that. Again, I would implore you to really consider this. Honorable Stevens, I really appreciate you bringing this bill to this point, and we'll be open for any questions.
Thank you, Dr. Gold. Any questions for Dr. Gold? Doesn't appear to have any. Thank you very much, sir.
Chairman, if you would allow, we have several patients here. Our apologies. We were not aware, and I think that we're not professional lobbyists. We're just
Okay.
constituents. If you don't mind.
I understand. And what my plan is today is I'm going to allow Representative Bruce to get with Chairman Stevens and let them try to work on the bill a little more to try to get a little teeth in the bill if they can. And at that point in time, we'll get back for a hearing and see what we worked out. Is that okay?
Thank you. Bless you. Yes, absolutely,
Okay.
sir. Thank you. We look
Okay,
forward to being
go
with
ahead.
you again.
Thank you. Chairman Stevens, we don't have leg counsel here today to work on the amendment. So we'll let you and Representative Bruce get together and see if y'all can come up with a solution.
Appreciate you, Mr. Chairman.
Okay. Thank y'all very much. Okay, we are moving on to House Bill 409. Chairman F. Stration, I think he's going to be presenting this bill for Chairman Gunter. So Chairman F. Stration. Okay, and you're 7? 8, okay.
Well, thank you, Mr. Chairman. And I know Chairman Gunter is online. I was planning to present it. I didn't know that he'd be online today. So if he wants to take over at any point, feel free to wave at me, or certainly if I miss anything, he can let me know. But really the issue that we're dealing with, Judge, is we have circumstances where our judges are faced with lawsuits that are really related to the nature of the work that they do. And the judges are left in a position where if the attorney general doesn't represent, state doesn't formally represent the judge may be left in a position where he or she is going to have to pay out of pocket for representation, or rely upon the kindness of another lawyer to just step in and represent effectively pro bono on behalf of the judge, just to step in, defend the judge. And so the concept that I think here is widely recognized is there's a need, but the concept here is to create a judicial legal defense fund that would allow for some money that could be appropriated really through the discretion of the governor to put into this fund, and then would allow for an oversight group that is made up of those appointed by constitutional officers and members of the legislature, leaders in the legislature and the judiciary, of judges who would help to administer and look after this judicial legal defense fund. The terms of service for this board, as well as the responsibilities that the state bar would maintain as far as a list of potential attorneys who could be designated to serve in this representation capacity is included here, as well as some procedural requirements about how this would work in practice when a judge is served with the summons and complaint, and the deadlines that would have to be followed for putting this in motion so that you could get an attorney under this put on to or appointed to represent the judge in the judicial proceeding. Certainly, happy to answer any questions if there are any, but would ask for your favorable consideration. Thank you.
Okay, do we have any questions for Chairman Efstration? Okay, the only witness I think we have is Deborah Nesbitt. And Deborah, are you on Zoom?
Yes, sir. I am here. Thank you for allowing me to speak very quickly. We just wanted to offer us our support for Chairman Gunner's bill. We have had confusion in the past about who ought to pay these attorneys' bills. Sometimes they think the county has to pay it. Sometimes they can't find anyone to pay it. So we just wanted to offer we think it offers some clarity for the judges who face this and for us, so we know what our responsibilities are in the way of providing representation. So we thank you for bringing the bill, and we do support it.
Okay, thank you. Any questions for Ms. Nesbitt? None? Thank you very much. Judge Gunter, I think you have a question.
Well, I did more of a comment. First of all, Chairman Efstration did a great job in the presentation of it. During my time as judge, I wasn't sued, but I was back when I was district attorney, and I kind of know how that feels. I know that Judge Chastain is on, and he and John Pridgeon experienced this a few years back and created a lot of havoc for them in their lives to deal with this. So I think it's a very important bill. I think one thing I would want to say to the committee is the governor's office has been involved in this, and they've actually asked for, I think, language to go in it, and I believe it's been put into the bill that I think gives the governor a little more control over the expenditure of the money, which is okay because it's coming out of the emergency fund, and I certainly had no problem with that. But that's the comment I had for the bill.
Thank you, Judge. Chairman Efstration.
Thank you, Mr. Chairman. I know that we have Superior Court Judge Tane Kell here from Cobb County, who's in the hall. If he could be called in at the appropriate time, he may be able to provide some comments as a witness.
Okay, Judge Kell, if you're out there, can you come in?
Thanks so much, Mr. Chairman. Okay, remove my mask.
Do we need to all stand?
No, only when I'm playing on my home court, sir.
Okay, all right.
Mr. Chairman, thank you. And thank you, Chairman Efstration, for your time this afternoon. And I'm really here to answer questions if need be, but I did want to point out a couple of things. This bill arises not because of a problem that happens frequently, but because of the urgency of the issue that does arise in the infrequent times when the Attorney General cannot provide representation to the judges. Attorney General has traditionally provided representation to judges in about 99% of the cases where judges get sued. They do it as a matter of comedy, as a matter of accommodation, not because they have to, because obviously their constitutional duty is to represent the executive branch and not the judicial branch. But where there is no conflict, they have traditionally taken up, without charge to the judges, the ability to represent the judges. However, there are circumstances that arise on occasion in which they cannot represent judges. For example, if the governor or some member of the executive branch is sued in the same lawsuit, which frequently happens, then obviously their constitutional obligation is to represent the executive branch. In that circumstance, what has happened, again, traditionally and under statute in code, I believe it's in Title 45 of the code, there is an ability for the judge to ask the governor's office to assist with giving representation to the judge. And again, the governor's offices have attempted to do that in every occasion. However, when that arises, there is no uniform statute, rule, or any other mechanism by which the judge is to ask for that representation or how someone will make that determination and under what circumstances. And there's also no funding mechanism. The governor's office has, this governor's office has indicated their willingness to fund those lawsuits or the representation out of the governor's emergency fund, which we greatly appreciate. We also greatly appreciate the Attorney General's representation in 99% of the cases. And I believe Wright Banks from the AG's office said that currently in his office, he believed there were approximately 100 lawsuits that were being represented. I don't doubt that. A lot of those go away on a motion to dismiss, as you might imagine, but many of them don't. Many of them have to proceed to summary judgment or some other stage. So what we're asking and what the judges have, it's not really our proposal, but the bill that came up and the bill that was proposed really evolved from something that was proposed about 6 years ago. In fact, the governor at the time was prepared to sign an executive order implementing something very similar to this, and it just kind of didn't happen. It kind of fell apart at the last minute. So that's where this mechanism came from, Mr. Chairman. And I'm just here today to tell you that while this is not a circumstance that comes up very often, if it's your ox that's getting gored, as my grandfather used to say, it's real important. And one of the provisions that I particularly appreciate that was inserted into here is the extension of time that's given to a judge who's sued in his or her official capacity to get representation and then file an answer within 45 days. And so that would be a great help to us too, so that if it goes first to the AG, then goes to the governor's office, then a committee has to look at it and determine whether representation is appropriate, we'd have a little bit of time to get the answer filed. So if there are any questions, I'd love to answer those, but I certainly appreciate the time of this committee this afternoon.
Okay, thank you, Judge.
Thank you very
any
much.
questions? No questions.
Thank you very much. And hey to Representative Gunner, if he's out there, he's an old friend. So it's
He's
great.
on the bottom right there.
Great to see you this afternoon, Judge. Can't wait till you get back. Thank you, gentlemen,
Thank
very
you,
much.
Judge.
Appreciate it.
Okay. Chairman Administration. Okay. Second. Okay, we have a motion to do pass and a second. Any other discussion? If not, can we have a vote? All in favor, say aye. Aye. All opposed? None. On the full committee. Thank you, Judge Gunter. Thank you. Thank you. This concludes the meeting. Thank you.